The next matter to come before the court this morning is State of Ohio versus Hopson. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, please let me know when you get started. I can keep you apprised of the passage of time. The court has read the briefs and we're ready to proceed when you are.
Good morning, Your Honors. May it please the court. My name is Charlene Bolin from the Ohio Public Defender's Office. I'm appearing for Attorney Brooke Burns this morning, representing the appellant, Torrod Hopson. I'd like to reserve 3 minutes for rebuttal, if I may. The issue in this case is whether the trial court had the authority to vacate any conviction other than the unlawful failure to register conviction. Before I address that issue, the issue that is before the court, I did want to take a moment to address the state's claim regarding the final appealable order in this case. The state mentions 250502, which is the final order statute in the revised code. And 250502 sets forth many avenues for a final appealable order, recognizing that not every decision rendered by a trial court is about the guilt or innocence finding. And particularly, 250502B3 permits appeals from a final appealable order if an order vacates or sets aside a judgment, and that's what we have in this case. That's exactly what Saxon is talking about too. It's preventing the court from vacating orders and entertaining a new sentencing hearing. So I believe that the orders that are before this court are final and appealable. Your Honors, the court erred when it vacated Torrod's lawful convictions in his other case numbers. As the Supreme Court in Saxon explained, Ohio does not have the sentencing packaging doctrine. Instead, the trial court must consider each individual offense, assign a sentence for that offense, and then determine whether those sentences will be served consecutively or concurrently. In this case, the trial court properly vacated the failure to notify conviction in case number 2012-0123. And that was proper under Williams and DJS. The Tier 3 juvenile offender registrant classification was vacated because it was unconstitutional. And the Ohio Attorney General Office recognized that it was unconstitutional and irretrievably removed that classification from Ohio's database. And the trial court recognized that a void classification can't serve as the predicate on which a failure to register is based. But the trial court erred when it also vacated the convictions and the sentences in the other case numbers, because those case numbers and the convictions were lawful. And under Saxon, the trial court could not vacate them. The situation in Saxon is really quite similar to this case. The defendant appealed only the unlawful sentence that was imposed for the 4th-degree felony. The state agreed that it was an unlawful sentence, and then the Court of Appeals vacated the unlawful sentence and also vacated the lawful sentence. And the Supreme Court of Ohio held that that was an error because it could only vacate the unlawful portion, not both of them. The Supreme Court specifically held that because Ohio does not bundle sentences like the federal system does, nothing is unbundled when one of those sentences is unlawful. So based on Saxon, the trial court could not reverse all of these sentences in this case. And so I would ask this court...
Why is the state arguing that Saxon doesn't apply if you want to anticipate your argument?
Your Honor, I believe that the trial court recognized Saxon in its journal entries in this case. I believe that the trial court also recognized that Saxon was controlling authority, but believed that there may be some distinguishing facts from this case.
Agreement?
I'm sorry, Your Honor?
Because of the agreement between the parties?
Yes, but under the facts in Saxon, it was a plea agreement. Some offenses were dismissed as a part of the plea agreement. And so really the facts are quite similar in Saxon, and so I believe that it is controlling in this case. And so I would ask this court to reverse the trial court's decision. I believe it's probably proper for this court to reinstate those convictions that should not have been vacated. The only conviction sentence that should be reversed was the failure to register. If there are no further questions. Thank you, Your Honors.
Court. My name is Richard Cassay, representing the state of Ohio in this case. I do want to address the finality, but I want to talk about Saxon for a second. So, there's Saxon convictions and sentences on 2 offenses, goes up to the 8th district. Erroneous on one of the counts, the appellate court vacates the other. So both are vacated and sent back. Supreme Court says you can't do that because that is the sentencing packaging doctrine, which someday I might understand, but the crux of it is that the trial court, when you're down at the trial court level, you have to consider each sentence individually and impose an individual sentence on each count, giving full consideration to what is the appropriate sentence on each count. So you don't want to have what the Saxon court calls a omnibus or a lump. A lump sentence, just, okay, we got all these, this lump sentence is good enough. That's not, we can't do that. I have some personal difficulty in taking that idea and superimposing it on an agreed sentence situation. With some background, I checked this morning on Westlaw. There's no case that I could find in Westlaw where the Court of Appeals cited agreed sentence and Saxon together, except to cite Saxon for res judicata, and that's in there too. I don't know that there's a case, I might be wrong, I'm wrong about a lot of things, but I can't stand here and tell you that there's a case that talks about Saxon, the sentencing package doctrine, as it relates to an agreed sentence. What is an agreed sentence? Okay, we agree, we've talked, he or she's going to plead to this, and we're recommending an agreed sentence of X years. That's not a lump sentence. I think it sounds like it is to me. So, when we talk about why doesn't Saxon apply to this case, maybe that's the answer. And I think the trial court started to go there. He agreed to this. And it was fashioned to benefit him. It's right in the transcript. We're doing this to help you, Mr. Hopson, so you can be eligible for judicial release in X amount of years. So, he agreed to that. Everybody agreed. That's what happened. Did the trial court give individual consideration to each count and what the sentence should be? I doubt it. I really doubt it. Here's a sentence, sounds fair, boom, out the door. So, I think that's what the trial court was getting at, if we get to that point, if we get over the finality issue. And really, let me talk about, back up a little bit. Plea bargains are contracts. He got what he wanted. Then, nobody knew at the time, the sentence on one is void because of the Supreme Court's jurisprudence dealing with juvenile sexual offenders. Okay.
Does the state concede that, by the way?
Yes, absolutely.
Okay.
If it weren't void, we'd have a res judicata situation, because it could have been raised. But it's void, so it has to be dealt with. So we have this plea bargain. He gets what he bargained for. Then we find out what the 3-year sentence is no good. So now he comes in and says, well, I don't want merely the benefit of my bargain. I want to get a super bargain because everybody made a mistake. Isn't that nice? I get 5 years instead of 8. That argument runs contrary, I think, to the law that a plea bargain is a contract. That, combined with Saxon's fit or non-fit with agreed sentences, I think may have been motivating the trial court when it said when the court said Saxon is distinguishable.
Of course, under contract law, there's a misunderstanding as to the terms, or one of the terms is illegal.
You don't have a contract.
Right.
So maybe he wants to go back and shoot for 40 years. I don't know.
You would argue that.
Pardon me?
Apparently that's your argument, then, that he would be subject to resentencing on all counts because of that, as opposed to.
Well, I think she wants to get a 5-year sentence. I think that's what she'll tell you. She wants to be sentenced for 5 years. Counsel said this court should reinstate the convictions, and then what?
Can we talk a minute about reinstating convictions versus resentencing and as it relates to your finality issue? Because we seem to be using those two words about vacating convictions and vacating sentences interchangeably. As I read the first judge's entry, which vacated the conviction for the failure to register, it speaks not to vacating anything else, but further sets it for hearing. Then the other attached orders, which occurred in March, indicate that the court has vacated all the sentences. We don't have that attached. I'm hoping it's in the record, but nothing that is attached here vacates sentences for the other charges, only vacates convictions for the failure to register an address. And that's troublesome when I loop that back into your finality argument, because I'm trying to determine if in fact sentences have been vacated in cases, then I don't see a finality problem. If it hasn't happened, then I guess the argument would be, well, the issue that I'm going to resentence you is a finality issue.
I think in the one of, if not all of them, entries, the court sets the matter for sentencing. Now, I'll stand to be corrected if that's wrong.
It does, and it vacates, it says on June 12th, the entire sentence was vacated. But that's not vacating convictions, and we're using those words interchangeably throughout.
I think what occurred is the court vacated the guilty plea, which would be the conviction and the sentence. That's what I think happened.
Okay. The arguments sound like that's what everyone thinks happened. I just don't see that in the.
I think if the court set it for resentencing, the court has to think that there was no sentence.
Sentencing, I understand, yes.
Okay. Well, if the only, let's say that the only thing vacated were the sentences. We still have the convictions. We still don't have a sentence here. We have convictions that have not been coupled with a sentence.
Right, but when the court says, when the court says, I have the authority, this is what I'm gonna do next, I'm gonna set it for resentencing, that is the court saying, I have the authority to do so. The argument would be, I think, on the other side is, you have no authority to do that, no
Right.
jurisdiction to touch those things. So, is that not final when the court says, I have the authority to resentence, to vacate sentencing?
Well, no, I have to say no, because that's the position I've taken here. The question raises a good point that frankly I've not thought about. I had just assumed that this is what the court had done. We set it for sentencing. What I think, under my understanding of what occurred, is that the courts entered an interlocutory order, subject to change. The court does not have to do what is in the paperwork right now, because there is no sentence. It's interlocutory. It's completely unknown. If there's been no appeal here, and the court just went on and resentenced, we can't say what that sentence would be. Now, obviously, the state would say he got aid given mate, but it's speculation that that would occur. So I think that's really what I was trying to get at in my finality argument, that it is completely interlocutory and speculative at this point as to what the outcome of this finally is going to be. I don't believe, I'm trying to remember, what happened was after the public defender filed the motion to vacate, I filed a response, and it sat for quite some time, and the court asked, is there anything else that you want to say to both of us? I said no, they said no. The court said, I will then rule on what I have. And then the court ruled. I don't know that there was a hearing per se prior to the court doing what it did. I don't think there was. For a fact, I never attended one. Then we have the end of this, where I think it was Judge Cosgrove. She said, okay, this is what the court did, and I was going to impose a sentence, but you filed an appeal, everything's on hold. So here we are right now.
Can I switch gears on you again
Sure.
one more time? Since the court says in its entry, Saxon aside, I find that the state is going to be prejudiced if we don't vacate the sentences and start over again.
Yes.
Is whether or not the state is going to suffer prejudice a factor in whether or not the trial court has the authority to resentence?
In some situations, it can be to talk about a tangent when there's a motion to withdraw a plea filed, and we get into these situations where years have passed. We have years in between. One of the proper factors to consider is, will the state be prejudiced by withdrawing this plea? Because now we have to try to prove this, and we have the passage of years, we don't have witnesses, God knows where the evidence is. So it can be.
And
But-
that kind of goes back to the conviction versus sentencing, because no convictions are vacated.
Apparently.
And when you withdraw a plea, obviously the finding of guilt is vacated.
Yes.
But here it's just sentencing. So that's why I struggle with, and Mr. Cassett, I very much appreciate your responses and discussing this with you. I'm not trying to make your case more difficult, but these are some of the thorny issues inside this particular
No,
case.
Your Honor, you're the ones going to decide, it's not me, so. I've said before, my time is the court's time. Prejudice to the state in this particular case, I think goes back to the agreed sentence argument. We agreed on this. So yeah, it would be unfair to the state and prejudicial if he can just bite out a chunk of 3 years out of the 8 and have it go on his way with the 5-year sentence. That would be prejudicial. So I think that, again, I wasn't there when the trial court articulated any of these words, but that's how I would interpret it. I have no idea how much time I have.
About a minute and a half.
Are there any further questions? Okay, thank you.
Thank you.
Your Honors, may I please the court? Just 2 brief issues on rebuttal. I just want to bring the court's attention to the facts of Saxon again, and I know that we did discuss them initially, but there was a bargain in Saxon. It started with a 6-count indictment, and the bargain in that case was that the defendant would plead guilty to 2 counts, and then the state would dismiss 4 other counts. That plea bargaining process was before the Supreme Court. It was squarely in front of the court, but the court did not base its decision whether there was a jury trial or whether there was a plea bargain. It just said that you can't vacate a sentence when that is not an unlawful sentence based on the sentencing package
Is there an
doctrine.
agreement as to the number of years?
Your Honor, I don't see that in the Supreme Court's recitation of the facts. I'll be honest, I did not read the briefs in those cases, so I don't know. But it's not in the court's recitation of the facts, just that there was a plea bargain based on the counts that the defendant would plead guilty
Okay,
to.
thank you.
And the second issue, Your Honor, just to bring to the court's attention, is that the problem with waiting until a new sentence is imposed is the court has no authority to do that, and that's what Saxon says. So vacating this entire sentence and then holding a new sentencing hearing is doubly problematic, because Saxon specifically says the court does not have authority to vacate the entire sentence. It's just the sentence that's unlawful, and in this case, that's a failure to register. There are no further questions. I appreciate the court's time.
Thank you.
Thank you, Your Honors.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision. It will be available to both sides, as well as posted on the Ohio Supreme Court website, which you can also access through the 9th District website. Thank you.